And welcome to Justice Serve TV. Boy, crazy day in Tallahassee as Donna Adelson is sentenced finally. And Kelsey Fitzsimmons, is she on the way to getting out of jail?
Justice, people say, justice.
Love you, Linda. Love you.
Justice, brothers say,
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And welcome to Justice Serve TV. Hi there, Michael Bryant here. Hey, did you get a blowout today?
Did I know I got a blowout. Actually, I did my hair last night because I knew I wouldn't have time today.
Oh,
So
okay.
I actually did it last night. And not only that, I was just waiting to say hi to you because you were really pixelated in the open. Again, you
Oh,
were all
really?
blurry, and I was listening today, and I heard people saying that you were blurry, and you
Yeah,
were never blurry. Your
I
opinions
blurred
are
in
never
and out.
blurry.
I blurred in and out. We're blaming the weather because the direct line, hard line Ethernet is solid and everything else is fine. So we're blaming the weather.
Well, you know what
Uh,
people don't realize it that when there are actresses, as they used to call them, now actors on the stage, there'd be like a soft fabric, right, on cameras and all, when you would see that soft look on their face. And the theory was the more the director liked the actor, the more that they'd be blurring them so they looked better, younger, softer, prettier. Now you just have AI.
That's right. Well, that's what I said earlier, that I was using the Elizabeth Taylor effect, which is either Vaseline on the lens or cheesecloth in front of it.
Cheesecloth is another one. Yeah, Muslim
cheesecloth is another one.
Muslim.
Hey, you probably noticed Bonesy is gone, but I have this in his place. See that? Our logo on the
Oh,
pumpkin
look
is our
at
logo
that.
color.
Look at that. You
Look
know
at
what? We had Darren Gelber on the other night. No one noticed that he had a werewolf behind him.
Oh,
Yeah,
yeah.
for our crime crackers here. We were just like solving that crime, right? There's a werewolf sitting behind him for
Werewolf.
Halloween.
Jeez. Well, Bonesy had to go out. Halloween's coming up, so Bonesy has rounds to make, and couldn't
Oh.
be here. So he'll be back. He'll be back.
Right. Well, Bonesy was in the courtroom today, I think. Wasn't Bonesy sort of in the courtroom? I mean, it was kind of Halloween. It was kind of like an interesting Halloween party at the sentencing. Donna Adelson, you were working. I was listening while you were working. Wow. I mean, what a day. What a
More
day
than
she
anybody
had.
would have expected. I thought this will be over by 4 at the very latest, and just after 5, it finally wrapped up. But yeah, it was a lot. It was a lot, and we thought what we would do, because we do want to get to Kelsey Fitzsimmons, which is really the case that's blossoming. We wanted to listen to some of the results from today, and primarily Donna's speech. She was speechifying. For those who didn't hear or were not able to watch it earlier, there was a question: is she going to say anything? Is she not? Is she? And there were a few witnesses, some buddies, saying how great she is and don't know anybody better, and can't imagine
I'm
she
sorry.
did this.
I give them credit, though. I'm sorry.
They're
People
friends.
that are your friends, they can't believe, and what they can't believe you did something like this, either because they can't believe it, or because it impacts how they feel about themselves, that they would be friends with somebody who could hurt them.
Okay.
You never know.
Okay, that's possible. But as we said from the outset, didn't change the sentence. That was going to be what it is. There was an issue with the second and third counts, which the defense argued for a departure, a downward departure, which didn't really fly either. And it's all just academic. But you had to understand that these attorneys were doing their job. That's what they are hired to do. And in a weird world, if upon appeal the top charge was reversed and remanded, the second and third charge might become an issue in terms of that sentencing. Again, when you got 30 years as a concurrent, 2 of them concurrent, so a total of 30 to be spent, consecutive to the life sentence, that means, okay, the life sentence goes away. You still got 30. And
Right.
she's 76, and I'm sorry, that's optimistic, but that's hard time. That's not hanging out at the country club type.
No,
hours.
but you have to lawyer. You have to do your
Yeah.
lawyering. And you know what? I wanted to talk about it, but hey, the judge was giving her a hard time, and then they wanted to redact things and all, and you can talk about that. But she'd been convicted of that. She's going away for life. I mean, I'd say whatever I'd want to say. I would use every F-bomb in the world if I were in her position. What the heck? What do you have to lose at this point?
Well, it was an interesting point where they said, yes, she wants to make an unsworn statement. And Judge Everett said, no, you cannot do that. Everybody, he says, everybody in my courtroom will make a sworn statement. No. And so Zellman had case law and said, no. And so the judge was very reasonable and was persuaded and said, all right. He didn't probably know what he was about to unleash from the defendant.
But he was wrong in doing that. If you're going to plead to a crime, then it has to be sworn, under oath. But if you've already been convicted, you have a right to allocute on your behalf, whether or not you're sworn or not. I mean, I have never seen a requirement that you have to be sworn to allocate after you're convicted.
It was very interesting.
That would be actually a violation of the Fifth Amendment. I think that would be actually wrong.
And he admitted it. And so they went forward with it. Missy, do we have her statement handy? We want to just listen to at a certain point, she does get cut off, but let's just launch into it. And for those who haven't heard this yet, again, this is Donna Adelson making a statement on her own behalf prior to the sentence being imposed for the conviction of murder, solicitation, and conspiracy in the death of Dan Markel.
Thank you for letting me speak. My son-in-law, Dan Markel, was a fine and decent man. He was well educated and passionate about his career. He was a good son-in-law, but more importantly, he was a caring and loving father. On July 18th, 2014, his car was followed, leaving his home. It should have been just like any other day, an ordinary day in the life of Ben and Lincoln's father, but it wasn't. He didn't know when he left his boys off at daycare that would be the last time he would see them, and the last time they would see him. He didn't know when he went to the gym afterwards that would be the last time he would exercise. And he didn't know when he drove home that his life would end within minutes. Danny wasn't just being followed, he was being hunted. He was brutally murdered in broad daylight, sitting in his car, in his garage, by vicious killers. I cannot imagine the terror he felt when he saw a gun pointed at him through the window of his car. I cannot conceive of his heroic efforts to stay alive during the hours after the attack. Danny died in the early morning hours of July 19th. His death is a loss to his children, his parents, his sister, all of us in his family, his friends, his colleagues in the legal community, and to his students at FSU Law School. Danny's boys each have a photo of themselves with their Abba, their dad, beside their beds. They grew up kissing the framed photo and saying, "Good night, Abba, I love you." But pictures and memories are all they have because cruel, cold-hearted people took him from all of us who loved him. My heart was broken when Danny died. My grandsons were going to grow up without a father who loved them. I wondered, how could we help these boys through this trauma? It was then that my husband and I knew that the best way to honor Danny's memory would be to share with these children an abundance of love, the love that Danny would have given them if he were alive. It is interesting how the state can't make up its mind about who is what they call the, quote, mastermind behind this murder. In both of Catherine McBanowa's trials, the state claimed she was the mastermind behind Danny's murder. In my son Charlie Adelson's trial, they claimed he was the mastermind. And now in my trial, they claimed that I, this grandma, was the mastermind behind the murder. I had no idea that other people planned to cut Danny's life short. And the people who did this are exactly where they deserve to be. But I had no knowledge that this horrible, evil act was going to take place. If I had become aware of this plan before Danny was murdered, I would have stopped it. With not one iota of actual evidence, the state convinced a Tallahassee jury that I solicited and conspired with other people to have Danny killed. Where is the evidence prior to the murder? The evidence beyond a reasonable doubt that the state needed to prove their case? Where is the evidence before July 18th, 2014 at 10:50 in the morning?
Before you continue,
that
Mrs.
revealed-
Adelson, as it relates to this statement, is the defense trying to re-argue the trial?
No, Judge, she's giving Adelson an opportunity to be heard.
Mrs. Adelson, you certainly can continue. However, the court can take into consideration the utter lack of remorse that you are displaying. Please proceed if you desire to do so.
Yeah, try and stop.
Where is the evidence before July 18th, 2014 at 10:50 a.m. that revealed that I had any involvement in this vile and horrific act? Where is the solicitation and conspiracy evidence? The state needed to show that there was evidence before the murder to convict me. The state couldn't show that because there wasn't any evidence. They were trying an innocent person. It makes you wonder if the jurors were sleeping when the state had Sergeant Corbett on the stand for hours. Their own star witness testified that my phone was never, I repeat, never at my son's house on the night of the murder. The state's theory that my husband and I dropped off money to my son was blown out of the water by their own witness. And yet, the state continued to push that story, that lie of the so-called money drop, to the jury through the remainder of the trial. And the jury bought into it, hook, line, and sinker. Reasonable doubt. Many months ago, my attorneys filed a motion for a change of venue. An expert witness testified that Tallahassee had been barraged with over 9 years of negative social media.
Can we stop
printed
it?
News, television news.
Missy has control. There you go.
Missy, can we? Don't you think that everybody?
I would like to award. I would
Oh
like
my
to award
God.
the Emmy to Donna Adelson.
It can't be the Emmy. You know why? She
No.
is so angry. She is so pissed off. Her teeth are showing. She is. You know who was our tickler tickling the wire? Who was our undercover agent who was so sweet and wonderful that he didn't fool her?
Oh, he was too nice,
He was too
Mr.
nice. Yeah, you all remember.
Jimenez, Mr. Jimenez.
Yeah. This is kind of like, remember when she called him back, and this is how she was. This is kind of like how she was. This is Donna Adelson, all right? And I think you can be really angry if you are wrongfully convicted, but what we see from wrongfully convicted people is that usually they forgive. And when she starts out saying that Dan Markel was a good man, if she called him all sorts of names, let me put it this way. You see this tissue of fake tears, throwing it away.
Yeah, I don't think she needed it. And what bothered me most was when she got into that whole thing about he was a great guy and he never deserved. She's just taking a big shit on his grave, knowing what she's done, and then to make it sound like I'm above reproach and all these bad people did this to him. He didn't deserve it. You're one of the bad people, and that's just the way the jury saw it. So. We don't have to listen to the whole thing. You listen to more?
No, we can listen to a little bit more, because what I want to say to you, if she had testified, this is why her attorneys talked her out of testifying. Remember when she was like, I don't know, Judge.
At the moment, I don't want to testify.
This, we're actually seeing the real Donna Adelson here.
Yeah.
And I think
and
it's
she didn't
wonderful.
get to testify. So this to her this is it. This is her performance to tell the world what she says happened and what she would have done in whatever way she could have gotten away with it if she had testified in her own behalf.
And if I were the judge, I wouldn't have interrupted her. I'd just let her go because she was building up a head of steam. Or maybe he was interrupting her because he knew that interruption would make her build up that head of steam faster. So we can listen to her.
I don't know, because she's like mid sob, that she stops and it's like, like the director yelled cut and she was in the middle of a take. Let's roll a little more of it, Missy.
And podcast publicity about my family. He explained to the court, both with evidence and demonstratives, that for me to receive a fair trial, it needed to be held in any of the researched and designated areas in the state of Florida, other than Tallahassee. All I wanted was a level playing field, but the court wanted the trial here, in the hotbed of Tallahassee. I sat through 3 days of jury selection. 180 potential jurors were asked if they had developed an opinion in my case. Those that answered yes also added, "I believe she is guilty." Not one person, not one, said, "I think she may be innocent." That should have been a clue to the court to grant our motion for a change of venue, but the court denied the motion. One of my jurors admitted during jury selection that she had background information concerning what one of the state's witnesses would be testifying about. Why was she allowed to be on my jury?
What moment?
Another juror.
Mrs. Fulford,
Oh, I didn't hear you.
Mr. Zellman, again, this has nothing to do with elocution of any sort. This is a raising of grievances, which are properly given to the appellate court. What does any of this have to do with sentencing?
Brad, just one moment, please.
You just heard, by the way, the appellate brief, which is probably she's seen sorts of drafts of, okay? And then she's incorporated that into this. So you just heard that, all right? And if you're Georgia Kappelman, as Georgia Kappelman did, let her go on and on and on, because you're getting all sorts of information about what the appeal is going to be.
Turn that phone off or step out.
Guess who that was?
Who?
Harvey.
Well, you know, he allocated, even though he wasn't being sentenced, he didn't do her any favors either.
No, he did not. He was angry and called the judge biased, said the jury was biased. That's when the judge said, "Hold on," and had Fulford actually edit, as she's doing now with Donna Adelson, had his edited, and it was like the Reader's Digest version after she got done with it. There wasn't much left.
I would have let her go on and on. I mean,
so she goes on, and let's Missy, if you could cue up his ruling, we'll chat for a minute while you're doing that, and we'll just go back to that. Yeah, I mean, she wasn't selling anybody. It wasn't any different than when she broke down at the time the verdict was read. So, you know, she got her chance.
I think it's worse. When time the verdict was read, she broke down, right? But this is pure, unadulterated hatred and evil of him, of the process, of the jurors. Now, that's
getting caught. Yes.
I think it's of getting caught, because she thought, I mean, all you had to do was listen to those tapes that they waited so long and hard on tickling the wire. And that's what really, she did it to herself. And then she thought she was strong enough to call him back. Remember, this is
remember what I thought was funny, but nobody would call him back. Nobody. Everybody kept trying to push it off, and ultimately the Donna did. You know, yeah. She had the guts to call this guy back. Everybody else was speculating: is it cops? Is it real? Is it the Latin Kings? I don't know. What do you think? I don't know. She's the one who called them.
As a matter of fact, when I got the call that I had to take before, when I see that it's like the police department, I take it, right? And then it went off. And it really was telling us not to go around barricades because of the water and all that kind of stuff. If you do it, you're safe, but I take it, right? In that situation, the murderers, the hit people were going to call this person back because they were scared he was a cop.
Yeah. And so she has the guts to do it, if that's the way I can put it, and is jousting with what we know now as the FBI agent. So anyway, all of this plays out over 2 hours before we get to the judge. And the bulk of the end of the argument was to get a downward sentence on the two other than top charges, conspiracy and solicitation. And people were getting annoyed by that. But as we said, you got to do that. You got to make those arguments. The judge had 2 prongs, which I think he goes through in the beginning of his sentencing here. Let's just say that he didn't have to spend a lot of time just saying, "Nah, I don't care. I don't care about the downward departure." And he went right along with what the prosecution asked for. So let's listen to Judge Everett.
And the grounds contained within section 921.0026, subsection 2, subsection B. In reviewing the trial court's notes, what has been argued by both the defense and also as well the courts relying on the record itself, court will find that there is a ground for non-statutory downward departure but it declines to exercise its discretion.
Wait, just
As
takes it back.
statutory ground, I will find that both the defendant was an accomplice to the offense and a relative minor participant in the criminal conduct. I will find that has not been proven, but in addition to, the court will still decline to exercise its discretion. As to the sentence in this matter, Ms. Adelson, please rise.
Stop it, Missy, for a second. Just stop for 1 second. I want to talk about that. So what he did there makes it like unappealable because he said, I find there are grounds, right? He didn't deny the grounds for a downward departure, but he says it's my discretion and I refuse to exercise it. So on appeal, he has to be abusive of that discretion. And that's a very hard standard to overcome. It almost hardly is ever overcome.
That's for sure. Yeah, there's deferential treatment to the court, and you know he went through the prongs. You know, there's a statutory and there's a common law. And he said, well, on this one, yeah, there is. I see you've met the qualifications for downward departure, but I don't want to do it. It's my discretion. So, you know, he just for a second held out a little olive branch and then yanked it back.
Okay, Missy, let's go to the sentence.
Level of planning and coordination to bring the murder of Professor Markel to fruition was significant in this case. These were not crimes of chance or opportunity, and these crimes also required you to conspire with your son and others. You certainly can choose to deny your involvement and maintain innocence. The court finds the evidence in this case is clear. You will be sentenced accordingly this afternoon. The jury has found you guilty on charges of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, and the court previously adjudicated you guilty as to the same charges on September 4th of this year. On count 1 of the indictment for first-degree murder, you are hereby sentenced to life imprisonment without the possibility of parole or release, pursuant to sections 782.04 and 775.082 sub 1 sub a Florida statutes. On count 2 of the indictment, conspiracy to commit first-degree murder, you are hereby sentenced to 30 years in the Department of Corrections that will run consecutive to count 1. The court will also sentence you to 30 years in the Department of Corrections on count 3. Counts 2 and 3 are to run concurrent with each other, but consecutive to count 1. As to the fees and costs, the clerk can please announce those at this time.
$2,100 is a fine pursuant to section 775.083.
Okay, we don't need the recitation of the penny ante administrative cost.
Yeah,
This was
but she
interesting,
certainly
though.
doesn't. She certainly doesn't look. You remember when she sat there as the grandma, the old grandma? She don't look like no old grandma now.
No,
she looks
she's-
like one hard. She looks like Ma Baker now. Ma Donna.
Yeah, we're going to see what the body cam shows if I can get that quickly enough. So what I found interesting early on was when Georgia Kappelman asked for restitution, and the number was $723,123.68. And they're going to have a hearing at some point in the next 60 days on that. I couldn't remember and haven't had a chance since I finished the first round today to check on the Charlie
And thank
situation.
you for that, by the way. And thank you
of
for
course.
that. You were on the air from quarter of.
It's only 2+ hours. That's not even like a real
2+
trial
hours.
day.
I know,
So-
but you really, but you were commenting, you were talking, you were listening. Thank you, Michael.
Of course,
I'm sure
of
everyone
course.
appreciated it.
So what's your take on, and if you recall from Charlie's situation, was the court receptive to issuing some sort of massive restitution bill, which in a lot of cases would be worth nothing because you have basically judgment-proof defendants. But in this case, there's potentially some money there.
I don't remember what they ordered.
I don't either. I gotta
But
look
it's
into that
the
again.
police investigation and the trial costs and all that, 718. And it has to be itemized. I think the court's going to issue.
Yes.
I think that even if he didn't issue it in Charlie's case, he is going to issue it here. Okay.
Yeah, she submitted all of the materials, basically the invoices. That was what, with her request, she said, here you go. So there's an itemized list that equals 723 grand plus. And the court's going to look at it later. I just wonder, because I think it's rare where you have a defendant that has some money. And there was early on when they had the pre-sentence investigation report. I don't know if you caught this or not, but the defense had some corrections. And most of them had to do with, typos and, dumb things. But the debt issues, they talked about the financial statement where she has no money, she has no home, she has only Social Security, which as a convicted criminal, that's now going to go away as well. I don't know if they were painting kind of a backdrop for being judgment proof.
Oh, you
Because-
will take that money and those assets are in some LLC name, some
Yeah,
name,
or
whatever,
Harvey's
some
Dental,
trust.
whatever. Or, yeah.
Yeah.
So I don't know if that was part of the process or part of the plan, but I can see it coming because that would I don't know what their total net worth is, but 700,000 will put a dent in most people's worth.
Most
So,
people don't have that. And by the way, Brooklyn, you're back. Hey, thank you. And also Joe Schmo's back. Thank you, thank you, thank you, thank you. And Madeira Beach caregiver, thank you
thank
very
you.
much.
She was here earlier supporting the cause,
She always does.
and finally hearing what she wanted to hear.
And then she's waiting for a breaking news alert on
Yes.
Monday because she knows how these trials have been going up the barricades. I wonder if there's any other tickling of the wire or whether that's been used up, and all.
How
on
dumb would
these
they have
trials.
to be to fall for that
Yeah,
again?
again.
I don't know.
Again, although you never know. Interesting, in her whole allocution, I heard her mention Charlie. I don't think I ever heard her mention Wendy.
Oh no. Mm-mm. No.
Right, everybody,
Nope.
you heard her mention
In any way.
and Lincoln anyway. You heard her mention Charlie. You heard her mention the other convicted felons. You never heard her mention Wendy, not once. What does that mean? Come on, speculate. I want some speculation from my the best in the business, Michael Bryant, and from all of you, our chatters, our viewers, our supporters. What does it mean that she never mentioned Wendy?
What if she's afraid of Wendy?
Her afraid of anyone?
No, I mean, what if I could see the opposite though? I could see Donna trying to maneuver her situation if she has to turn on somebody, Wendy or Harvey. Wendy in her mind already has turned on her, right?
She's not
Harvey,
going to
not
turn
so
on
much.
Harvey. She's not
going to turn on
Harvey.
But maybe on Wendy, if she could lighten her load, I don't know what she could possibly do that would help her out. She's just too, she's doesn't have much life left in jail years,
Yeah, no. Harvey was it was interesting because we were all saying, well, Harvey's probably enjoying his life without Donna. It does not appear that way. When someone's cooking your dinner, doing your laundry, making your dinner reservations for you, maybe he misses all that.
Hey, we went through this a little earlier. I don't know if you caught part of this when we're waiting for the hearing to start. This is the latest phone log talking about Harvey. Oh my gosh.
Oh, I missed that.
Just a sampling of a few days. I looked at, she had the usual, incomplete calls, but of 179 calls, 115 were completed. Of that number, 106 were to Harvey. And on a given day, I just looked at a couple of days here, September 25th, he was on the phone with her between 9 a.m. and 9 p.m. for 5 hours. Now, that sounds like jail to me. Is that what he's got to look forward to now? Is day after day of listening to her piss and moan about prison? Because what else is she talking about? Nobody's talking with the family anymore.
Yeah, she's pleading her case. She's pleading her case. Maybe she's expecting Harvey to go to Wendy and set her free. I just I don't know. Obviously Wendy hasn't talked to them, and Wendy's not planning to talk to them. And Don and Harvey, I think they're like this after 54 years of marriage.
Yeah, I don't think he's got anything to worry about from her. But who knows in the bigger picture if he's got something to worry about or not. We'll see. I speculated that when he got that phone call, it was the travel agent confirming his one-way ticket to Vietnam. But I have not confirmed that yet.
Yeah, and you notice, by the way, she spoke loud and clear. She stood up straight and clear. Be interesting.
Where are the headphones?
And we're no headphones. And talking to our lawyers, no problem. It'd be interesting to see when you, because I know you said you've already applied for the transport video. It's going to be interesting to see what the transport video shows this time.
It will be. And I also asked for phone calls, but they will not release those to the media without like a subpoena of some sort. So even though all of these calls now that I have documented, and some of them are very lengthy, we can't get those at this point. I was going to throw out there were a couple of numbers with names on them that I can't combine. They're from North Carolina. I know there's a connection with the family there, but there's one person that she called 13 times. And again, this is over about a 3-week period. One person from there she called once. And then there was the LA attorney that apparently is no longer practicing that she called once in Granada Hills. So I don't know. Timothy Gregory Johnson in Raleigh, North Carolina. That name is so familiar because I saw it come up in the first time that I looked at the records, but I can't. Somebody must know. I'm just missing whatever that connection may be, whatever it is to North Carolina.
Yeah.
And then Ann Cunningham made a call again, just one.
And she also supported her, right? I mean, they
Of course, yeah.
they supported her, and again, I have no problem with that. I don't want anybody to go after those people. That we should all have friends that would support us if we think that if I think that my friend is wrongfully convicted, which they clearly do think that she's wrongfully convicted, and they should all support her if they think that. So that's don't castigate them, go after them, don't make fun of them. That's you want friends like that who think that obviously they don't see the other side of you, and that's what do we always say when there's a serial murderer that's caught? And the neighbors come out and say,
he was so quiet, kept to himself.
He's the nicest person. Always kept himself. Was just so help us out. Just so nice, right? There's always can be a dual side.
So maybe we'll do a short to get into this in a little more detail. We'll see what I get from the Leon County in the next day or so. So we'll set that aside for now, since it's interesting in retrospect. But right now, bigger Donna Adelson issues to deal with. And I shared this earlier just because it was, let's see if I can find it again. You know me, can't always find the thing I'm looking for. It was just such a, demonstrative way to show what a difference a day makes. There's Donna the day before verdict. There's Donna the evening after the verdict. And we'll see if we can get some more of that, some of that body cam footage. They say there's no other transport footage, which surprises me, that there's not a static dashboard camera shooting back. Because not that it would happen. It's not like this is Con Air, but what if she were to get loose and she could effectively sneak up on the driver? I don't know why they don't have transport cameras, but they say they do.
But you know what you should do, and I don't want to give you more work. You should do one of Donna in court when she's like, "Oh, I don't know if I should testify," compared to today.
With her
Rottweiler. Thank you, Donnie Not Wahlberg, for the Justice Service.
Thank you.
It's already probably been gifted out to somebody in our chat. And that reminds me to get one of these from our nice subscribers who donate to us, members who donate to us, everyone donates to us. And then you get them. You have to be a subscriber. So smash that subscribe button, share, like, and notify. But you can't get one of these free memberships that are so graciously given out by others in our chat unless you are a subscriber. So hit that subscribe button.
Yep. So we're going to, more to say on this, or should we wrap up and move on to Kelsey?
I think we're good unless you all have something else that specifically you need us to answer, because I know you're going to want to go watch Donna for yourself.
Donna. And speaking of watching stuff, for those who haven't seen our video with Sean Paul Reyes, it's almost to 100,000 views. So you might want to check that out when you get a chance. Look into our library for that.
And people chatting all over the place. And by the way, we're at over 31,000 subscribers. I think a lot of that attributed the last 1,000 because of the Sean Paul Reyes video.
Yep. Yeah. It's funny. He's very divisive. It's probably about 80-20. 80% are in favor of him and the First Amendment, that crazy idea, First Amendment. But there's some naysayers, and I think they're amusing. Anyway, so Kelsey Fitzsimmons. I wish I could say that the Supreme Judicial Court of Massachusetts has ruled and she's getting out. Not quite there yet. They're off today. They were taking your holiday today, LKB, Columbus Day. They were taking it for you.
I actually bought somebody to help us with the medical aspect of this.
Okay, wait a minute. Is this the Ed Sullivan show? Doing it.
This is Doc, okay?
There's
besides my husband, the Doc, there's a Doc who lives in this house. And since we were going to go over what the states talked about, okay, in the Kelsey Fitzsimmons response, I thought that when we got to the medical evidence, we should have some help from somebody who may know better. Doc.
Okay. All right. Uh-oh, ripped his head right off there. So we're going to hit a couple of high points of the state's rebuttal response. Go ahead, and I know you've gone through it today. I saw it over the weekend, and I spent some time just working on the audio because I think it all circulates around that September 11th, 2025 hearing in which Tim Bradel took his client in and said, "Can we do a tweak to the conditions of release? This scram breathalyzer hurts her broken ribs and other injuries." Right, Doc?
That's right. That's what docs would say. It hurts
That's
her
what Doc would say.
injuries.
So we're here just to do this. No, there's been no violation. Let's just do this. So everything in this major petition and the response circulate around that hearing. You got to hear that hearing if you have not. You got to hear that judge. You got to hear the lack of the prosecutor doing much of anything. You got to hear the probation guy who's actually lobbying to help Kelsey Fitzsimmons.
Right.
So let's set this up by hitting your high points from the response.
Well, what I'm furious about is that, number one, they allude to the fact that she needs to have the scram monitoring 4 times a day, breathing in, because in 2018, okay, before she was a corrections officer, before she was a police officer, before she was certified, she had a drunk driving, apparently, down in one of the Carolinas. And
she was 21. It was a bridal shower, I believe it was.
Right.
And they got a little excessive, and she pled to a misdemeanor.
Yeah. And then the state, the Commonwealth, okay, and I don't know who they're commonly wealthing for, but they had their footnotes are atrocious. They say that when defendant filed a letter summarizing her injuries, because they had to do that because they were being manipulative, just like the judge said, the letter from the doctor didn't say that breathing would be painful. She said that breathing would be painful. Hey, doc, what do you think? Okay. You're in these 7 dwarfs. You have a lot of brethren, right? You think breathing would be painful if you have a bullet wound in you? Yep. Matter of fact, he agrees. As a matter of fact, even comes with his stethoscope. Okay. All right. And this is a real stethoscope.
It looks like a real stethoscope.
I mean, I just find this.
We'll hear the judge say, "What proof do I have she has a broken rib? What proof?" That's what she says. They had a letter from a surgeon. The surgeon, how hard is it to do that? They get a letter from the surgeon saying, yeah, she's got a broken rib and this is healing, and that kind of activity could certainly cause pain for some time.
And then the other thing that got me on this, when you read we're not going to go through all the details of it, which really got me. They said, well, the judge had no idea that there could be alternatives to having a scram.
That's just a lie. That's a lie.
That's a flat out lie. Of course, everybody knows you can take a urine test. You could take a blood test. Of course, everybody knows you can have a plain ankle bracelet with it. Yeah, everyone knows what the options are. And said, well, that would mean that she'd have to go out of her house, and therefore that would modify the conditions. So what? Even if that were true, but it's not true, because you could have somebody come in. You could pay for somebody to come in and take the testing. It's done all the time. It's disgusting. It's depressing. It's outrageous. It's demeaning. It's lying, and it's just plain flat out injustice, and it's wrong. And the fact that Commonwealth filed this piece of crap in response, to me, is even worse, because then they're doing nothing but supporting the fact that the justice system is an injustice system, is a piece of crap. And Massachusetts, who I used to think very well of, because as I thought we had a fair shake in the Hernandez trial when we were in Suffolk County in Boston with a great judge and a great courtroom facility. What I have seen since, obviously, something stinks in Denmark, and Denmark is now in Massachusetts.
I just wonder what the motivation was for her. Why would she care? I mean, why would she be so against doing the right thing for this person? I mean, is there some bigger conspiracy going on that it smells like the Karen Reed case? Is it what would motivate her? Does that make her feel good? Does she feel challenged because Bradel said, "Hey, we want this tweaked," and it was 3 days after the original condition release? I don't understand.
I don't know. And then if you also read what the state responded to, the state has like 2 different aspects, 2 different stories of what happened. It says her mother, by the way, came. There were cops downstairs, and they heard the cop who eventually shot her say, Kelsey, no, don't do it, Kelsey, don't do it. And then, but then it says, well, he actually took out the gun. She had pointed the gun at him, and he only shot her because she was going to shoot him, which doesn't go with, hey, Kelsey, don't do it. She's not going to tell. He's going to shoot her. He's going to say, don't do it. Don't do it. Goes with, I was committing suicide.
That would not be the default interpretation. I mean, anything could happen in the moment. I'm not going to I wasn't there, but to hear somebody say, Kelsey, don't do it. It's not like they're pointing the gun at me.
Right.
I'm not going to be pleading with somebody.
No, I'm going to shoot her right away. Unbelievable.
So.
By the way, Joey Kane, thank you for gifting that.
Thank you, Joey Kane. I saw some note fly by there that, Linda, you must have the only good judge in Massachusetts. There seem to be many others that are not so good.
Yeah. Oh, well. But we did have the court clerk in Hernandez's case was the former attorney general who was convicted. She was the one who had all that with the lab and lied and lost her lawyer's license and all that kind of stuff. And she was our court clerk. She was wonderful to us, but that all happened afterwards, that she was the one that was at least identified publicly. So things happen.
Okay, what else you got to beef about in that document?
All right, that was my
those are the
beefs.
main ones?
Those are the main ones, right?
The thrust of it was the judge was right, the defendant's wrong. She should stay in jail because she did not comply with Scram. That's it, and they go 23 pages to tell the appellate court just that. And again, from my conversations with the clerk, this is a single justice petition, which is really, I kind of like that in Massachusetts. It's one of the only places that does it. It came from England, Wales, they still do it, where you make a request instead of to the court en banc, where they may be slammed, you can get one justice, and so they can handle more of these emergency petitions. But they don't normally have oral argument. And that was confirmed by Bradle's office. At that point, they hadn't been told. If it were to happen, it would happen. We'll learn about it like tomorrow. Right. But we may also have a decision as quickly as tomorrow. So because this all boils and rolls around this 20-minute court hearing, I thought it might be helpful. Hold on, quit talking while I'm talking there. The
Kelsey
tape.
Fitzsimmons.
Hold on. Don't get anxious. You could heard that, right? You heard that?
Yes, we can hear that.
Okay, good. Okay, so I figured let's listen to this again. And it's subtitled, which is helpful, but it's pretty clear audio. And see how this judge treated the parties. And by that, I mean the defendant and her attorney. And what the prosecution did or didn't do. And then even Mr. January, who was the probation officer, is fascinating. Linda, let me know if you want to stop and chime in at some point. I'll do this.
No, but I would put up the DA also know the Bradle cursed at the judge after the judge got off the bench, which
was cut off. Yeah, it was cut off. The audio clip.
Give me a lawyer who hasn't cursed at a judge when they're off the bench under their breath. I
think he had to be stunned. And she was running from the bench. She wasn't hanging around, clearing up paperwork and leave. She was gone. So.
Calling Commonwealth versus Kelsey Fitzsimmons. This is docket number 2025-311 before the court in the defendant's motion. If the parties would please identify themselves for the record.
Good afternoon, James Gubichowski on behalf of the Commonwealth.
Good afternoon. Good afternoon. Good afternoon. Good afternoon, Your Honor. Martha Cooley. Good afternoon.
Hello, Your Honor.
Good afternoon. Good afternoon.
Thank you.
So I received the defendant's emergency motion for immediate release from the Scram order. So I'll hear from the moving party.
Thank you so much, Your Honor. Judge, this is an issue that causes Ms. Fitzsimmons a lot of pain. And I don't want to conflate her being able to pass the test because she's been passing them, but she has about 4 hours of pain and dizziness afterwards. And I don't think anyone, and I know the court would share my thought that this shouldn't be a torture device for her. This shouldn't be something that causes her pain, impairs her rib healing, et cetera, et cetera. So, we're not trying to get any sort of advantage over anything.
Keep that word torture in mind because it comes up again at the end, and listen to how the judge latches onto that.
We just want her to not be in pain for hours after these tests, and B, we just want her to not have the anxiety that if she has a difficulty doing it, that she's going to get a knock on the door and get locked up. We were told by the Elmo people that, they may have to issue a warrant, and thankfully they didn't. And we appreciate, you have Mr. January's email regarding his own observations about what happened. And, I think that says it all. That's someone that has no bias or interest, and, probation enforces court orders, and that's that. And he is telling the court this is a problem. And, this is something that should be addressed. And
Okay.
so I see this as a simple adjustment of terms.
I don't see it that way, just so you understand where I'm coming from. I don't see it that way.
Okay,
Okay.
I don't understand what you're saying, Judge.
Okay, what I'm telling you, it's not a simple adjustment. One of the reasons she was released, one of the reasons to ensure the safety of the community was for her to be alcohol-free. If she cannot do that or will not do that, that changes everything.
She's happy to be alcohol-free. She doesn't wish to be alcohol-free. It's just the means of determining that's the adjustment. That's what I mean when I say this is an adjustment that.
Well, a scram is what was ordered. Now, was she unable, when you said that there was a knock on the door, explain that to me.
No, we don't want to have a knock on.
Is she listening? Does she ever listen? He's saying that we're afraid with this difficulty in completing the breathalyzer test that the folks at Elmo, which is kind of the enforcement center, they'll reach out and say, hey, she didn't file a completed breathalyzer, and then they will send somebody, and there will be a knock on the door. The judge is, try to stay up, keep up. It's not that tricky at this point.
Or she's living in fear of there being a knock on the door because of these tests. It's just not between the physical and then the mental anxiety. This is a very significant issue for her.
Okay.
And that, we just want to adjust whatever means the court wishes to test her or figure this out is fine with us. But this is just a very difficult environment. And that's something that I just want to ask the court to adjust somehow.
Okay, so you're asking the court to adjust the court's order that's been in effect for 3 days with no medical evidence to support your claim that she cannot do it.
Well, I think you have 2 affidavits and the email from probation. I think that's pretty persuasive evidence that this is extremely difficult.
The email from probation is not evidence. If you have any evidence, now is your opportunity to submit it.
I don't understand the court's position. That's not evidence.
Okay, it's an email. It's hearsay. Commonwealth, do you have a position as to the submissions of an email as evidence in this hearing to relieve the defendant, Ms. Fitzsimmons, of a condition that's been in effect for 3 days?
I don't want to put
Can we
anybody
stop
on the
it?
spot, but
I have an idea.
Yeah.
I have an
Yeah.
idea. It
Yes.
has nothing to do with either case, but it has to do with both cases. I think we should have I don't know what you want to call it, a face-off between Donna Adelson and this judge, okay? And what is it? Because when I'm hearing Donna Adelson speak, we just had it, and I'm hearing this judge speak, the attitude, the anger, the disgust to me is all outrageously the same. Okay.
Yeah. And unfortunately, one is a judge, not a convicted defendant. So here's where the first horrible mistake is made, and that is that she's saying, well, that's hearsay, that email use. We know that procedurally in this kind of hearing, hearsay rules do not apply. She either doesn't know that, which makes her a totally incompetent judge, or she's ignoring what she knows, which makes her maybe a judge operating outside the bounds of the law. Neither one is good, but she is adamant that that is hearsay, and that hearsay does not come into this courtroom. And so she's now looking for evidence. Where's the medical evidence? She doesn't think it exists.
And it's only been 3 days. To me,
Yes, it's been 3 days.
3 days is good that Brado came back in and said, look, we just tried this. It's not, can we do it now instead of waiting? Because if she came back 2 weeks later, they said, why didn't you come back 3 days from that? Why didn't you wait 2 weeks?
And this guy, James Gubatosi, he's the ADA who just is the mealy mouth, who has been asked by the court now, well, what's your position on this evidence coming in to support their claims? Does he say, well, Your Honor, we acknowledge that in this setting, hearsay rules don't necessarily apply? I would think he has an obligation to educate the court if the court's misapplying the law.
condition that's been in effect.
Here's,
for 3
listen to what he
years.
says.
I don't want to put anybody on the spot, but we have the person who sent that email here.
Okay.
I don't want to put anybody on the spot, but I have the email. What is that? What a wimp. I looked for a picture of this guy just so we could see him. And you can see that I pop in and out the judge's picture here. And I do it purposely because she's interrupting all the time. So I didn't want to leave it up all the time. It's like she's just popping in and interrupting.
So you have a burden, it's your motion. What do you want to do?
Well, Judge, I don't think that is the court saying that papers and emails and affidavits are not sufficient?
This is an email from a probation officer. The court gives that 0 weight.
Well, then you have an affidavit from Ms. Fitzsimmons and you have an affidavit from her mother of the physical observations of what happens. I think that's, the more persuasive evidence than a doctor saying something to the effect of, I think it's self-evident and it's common knowledge that if you have broken ribs, that it's hard to breathe.
What evidence do I have that she has current broken ribs and that she's suffering from broken ribs at this time?
Well, you have an affidavit from her mother, you have an affidavit from Ms. Fitzsimmons, and the other day we were here, I submitted the instructions from Mass General about broken ribs.
Okay.
I mean, I would just argue that it's somewhat self-evident as well. Thank you. That it's somewhat self-evident as well, and that she's having great difficulty here. It's been observed by probation. It's been attested to by her mother, and it's been attested to by Ms. Fitzsimmons. So it's just a very difficult scenario for her. That luckily she has passed the test, but then she's got hours of pain afterwards. And the one that she had difficulty with, out of an abundance of caution, we were dealing with Elmo, and we were informed that they may issue a warrant. And
so I want to hear about the one she had difficulty with. When was that?
Well, so that's what I was saying. Judge. I don't want to conflate passing with not having difficulty. She has difficulty with every single test, and so she passes them in great pain. So she's had difficulty in every single one. Equated, it's in the affidavit. So she has difficulty on every single one. So that's a different issue than passing the test. So she's experiencing difficulty all the way through. But the one that she was unable to was 9/9/25 at 3:09 p.m., I guess.
And was that a required test that she was to do?
Yes.
And she was unable to perform it?
Correct.
Okay. Was she unable to perform it?
No.
What happened?
So since she's been released,
Yes, where in office?
Would you raise your hand, please? Do you solemnly swear you will make true
So this is Probation Officer January. We won't go through all of his, but you'll get the flavor of what he's trying to do with this judge.
answers to such questions that may be put to you by the court or upon its direction, so help you
I
God?
do. Or if I could just pass this up, this is
Sure.
information pertaining to all of our students.
And is that being submitted, Attorney Bradle, as an exhibit for the purposes of this hearing?
Judge, I'd be more than happy to do that.
It's not more than happy to. You're either doing it or not.
Yeah, sure. Go right ahead, Nora.
Okay,
it
so
just says that she passed the test, so which
Charming.
is not an issue. The issue is that she's in extreme pain while doing it. Whether she passes it.
Okay, so there's one, Officer January, that says incomplete at 9/10/25 at 3:09 p.m. Is that right?
Yes, that's correct.
So what does that mean?
Yeah. So what it means is there's a scheduled test that's programmed daily for her to be alerted and to initiate a test. And that happens. And so initially she answers the alert and attempts to take the test but is unable to complete the test. And based on my information, my conversations with Elmo is that is when she has difficulty either blowing as hard or as long, or a combination of both, into the machine to complete the test. So what happens after that is there are additional attempts to complete the test, which she tries. And then ultimately on that particular date, she successfully completes and passes the test on September 10th at 3:50 p.m.
Okay, what I have in front of me is an incomplete test at 9:10:25 at 3:09 p.m.
That's correct. And then if you just look
And then
right
it
above
says
that,
passed at 9:10:25 at 9:30 a.m.
okay, so you're looking, I'm referring to this second document. It's multiple pages.
I think if you just go up instead of the one above it, the
Okay.
incomplete is the.
So it's 3:09, it's incomplete, and then at 3:50 she passed.
That's correct.
So that's a period of 40 minutes.
That's correct. And you'll see the same thing.
So the other one, which is
September 9th, yes.
September 9th,
Again, at 3 o'clock.
she passed, but
The test is initially incomplete.
at 3:09, and then it's complete at 4:21.
420, 421.
So there were 2 times that she had an incomplete test. Is that
Yes.
correct?
And
And what's the procedure of the probation department when somebody who has a condition of release to have a scram and to pass the scram test in a very serious case if they're incomplete? And I have 2 incomplete tests and I was not made aware of either one of them.
She is so insecure, and it comes across as angry because she has no clue. She couldn't even tell her to read these results. No clue. Everybody's trying to help her figure it out. And now what's coming is very important. This is the probation officer basically saying, look, this happens all the time. And when it does, we don't consider that some sort of violation, but listen to how the judge handles it.
so my first job when we get an incomplete test is to gather more information. And so, which is what we do. And so in response to the incomplete test, we call Elmo, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. Ultimately, at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test.
So that's for a period of
And so
an hour and 20 minutes.
that's correct. Now, in conjunction to the hour and 20 minutes, we also know that, and I observed it firsthand, that whatever the injuries are, which I don't know, actually doesn't really matter to me. But when I was doing the installation process and observed what was genuine pain, genuine pain. So I know
Any objection to any of the terms used by the probation officer?
we have all that information. We don't deem that non-compliant. She's attempting to take the test and she ultimately passes the test at 4:20. So with all of the information, that's not non-compliant. That's compliance, and with her obstacles.
What do you, I'm getting confused. What do you mean compliant? As far as when she was initially,
that's compliant with scram testing. She was ordered.
when she initially was, started to be monitored by scram and you went through the preparations, is that right?
Yeah, that's correct.
Okay. So when something is incomplete,
looking
you
for a way
typically
to
bring it
make
the
her
attention
non-compliant.
of.
What's
She is
that?
looking for a way to make her
Yeah.
non-compliant. She's
Whatever
absolutely looking for a way to make her non-compliant.
Whatever it takes to put her back in jail. Okay, call that non-compliance, call it failure of whatever it may be. The judge just feels like, well, she's violated the rules. I don't care if she's here voluntarily or not. Now we got her.
No, that's not what we do. So if something is incomplete, as in this case, on September 9th at 3:09, we have an incomplete test, which is a scheduled test.
Mhm.
And then we have, that's simply not the non-compliance. If she had missed the test, that would generate additional responses from Elmo, and then that would determine whether or not there's actual non-compliance. If someone missed a test because they were down in the basement doing laundry and then came up and realized that they had a test, took an on-demand test 20 minutes later and passed the test, which means there's no alcohol in the system, we don't deem that as non-compliant. That's compliance. If they missed the test and additional notifications were made by the electronic monitoring office regarding the missed test, and she failed to respond or she failed to take an alert for another on-demand test, now that's non-compliance, and we would initiate a pretrial violation notice and notify the district attorney's office.
The guy's going out of his way to try and explain to this dumbass judge how it works and whether it's compliance or non-compliance, and it doesn't sink in. For those who don't know what this thing is, let's say this is the scram, right? It will have programmed into it, in this case, 4 different times a day that she had to blow. Okay.
First, it has an identification. So
yes.
you know it's the person.
It's not, and it's not, you don't pass it around. It's, it's connected to you electronically, not physically. And it beeps and you go, oh, I got to take a test. And so he's saying, if you're not in the room, it'll keep beeping basically until you take the test. And at a certain point, if you ignore it long enough, then they might start looking into it to see why you haven't complied. There's an interesting discussion coming up here. I want to play part of this because it is fascinating, talking about the difference between a scheduled test and random. And just listen to the judge's
particular case, I don't deem non-compliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's,
Well, that's your
for me.
That's your position. That's non-compliant.
Well-
it's really up to the court to decide whether somebody's compliant or not. With
You know what
conditions
gets
of
me?
release.
Stop it right there. Just
What you're
stop
saying
this
is-
before we go on to it. It's clear to me she's never had one of these, okay? Because she needs to be educated as to how it works, how it operates, and how the probation department operates. So it's clear to me that this may be the first time she's had one of these issues.
Well,
Okay,
you're
I
giving
just
her a
think
break. I'm not willing to give her. I don't know that for sure. I think that
I
would
don't
be
think that's- I don't
so
think
weird that
that
this
she
is
didn't
the
have it.
first time.
Yeah,
That would
I
be
know,
weird.
but she's asking questions like she's dumb.
Well, there you go. Now that I'll buy. Dumb, I'll buy. First time, I don't know. It just sounds like I think you were right before. She's going out of her way to find non-compliance, even if it means, whoa, what do you mean? The sun comes up in the day and goes down at night. She's just pretending, I think, to not understand how this works so she can get where she wants to go.
Those
There would
situations
never
you
ever-
described is what you deem as appropriate to bring before the court.
It would, so I guess it would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation or from our end.
Right.
Because there are many reasons for a test to be incomplete. And there are circumstances where someone misses a test and then takes an on-demand test. That's not intentional non-compliance. And the goal is to test to ensure that the person's sober. And that's we don't deem that non-compliance. That we never have, and we never would, in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. And so the schedule for her to be tested,
Here we go,
is something that we discussed. Wasn't ordered by the court. The court ordered someone to be alcohol free.
What do you mean we discussed? So she knows when she's going to be tested?
With Ms. Fitzsimmons. I discussed with the defense counsel about creating a testing schedule because it's it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency of testing that was ordered by the court.
It was
4 times a day, 3 times a day. None of that was ordered. She was ordered.
It was random screens, excuse me, Ms. Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me?
We created a schedule,
With
as we always do.
Okay.
As we always do. Not in this particular case. We always do.
It was random
Guy,
screens. that
at
were
least
ordered.
this guy
I don't have
is
that.
this
I don't
guy,
have any-
Mr. January. He's upstanding and he's
Yep.
honest and he answers her and he's not afraid of her and all. She's being a jackass, and quite frankly, the district attorney who's sitting right there and just like sitting there being useless as a piece of lint on a black dress, all right, is also, as far as I'm concerned, at fault here, along with the Commonwealth going to the court and objecting to Bradel's papers.
Yeah,
But
again, his name is James Gabatosi. Gabatosi. Yeah, he's not good. And I know that it put him in a weird position. I get it. But, down deep, can't you just do the right thing?
yeah, stand up to the judge, do the right thing.
But he couldn't, and he didn't. And so when the Commonwealth makes their opposition, which has such ridiculous lies in it, it makes it sound like he was jumping on top of the desk, objecting to what was happening, when we've heard what he really was or wasn't doing.
Screens anywhere in my materials, for the record.
Okay.
I don't know nothing about random screens.
Okay.
Judge, just so I could clarify that. When we get an order, someone's placed on pretrial conditions that include remain alcohol-free with scram testing, we always default to creating this testing schedule,
Okay.
and up to 4 times a day. So we'll schedule one for the morning, we'll schedule one for the mid-afternoon, we'll schedule one for the evening, and if we have to, we'll schedule one for later at night. And that's to ensure that sobriety throughout the day. In this particular case, we created a schedule for her to be tested at 9:30, 3 o'clock, and then at 8 o'clock. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the tests are coming. And the test to be done randomly. And at that point in time, we would take her off a schedule, and then we would notify Elmo to be tested 4 times a day at random.
Okay.
So that's done on this case, and it's done on every case.
Okay. Attorney Bradel, do you have anything else to submit?
Judge, I would just offer, I respect and I heard your Honor's take on the probation email, but for the record, I would move that into evidence as well. And I just want to also.
Commonwealth, do you have a position as to the admission of the email?
Well, I think we just heard with the email.
All right, so the email is excluded. Anything else, Attorney
No, my
Bradel?
objection, Your Honor.
Sure.
And Judge, I just want to state that on the pretrial conditions of release, it says comply with remote alcohol breath testing.
Okay. I don't know if that's what was ordered. I'm going to go back and listen to FTR.
I can tell the court from where I sit, I didn't remember any use.
I mean, you may very well be right, but I'm going to go listen.
Judge, I just want to clarify something. My email, and I know but it's important that the court knows, I didn't make a recommendation that the scram condition be vacated. I never did that. I never suggested, it's all that email was.
Attorney, Officer January, nobody's asking you questions. Your testimony is complete. Are you asking to make a statement to the court?
If the court's under the belief that I recommended that condition be vacated or removed, then yeah.
I haven't said anything one way or the other, sir. We're here for one purpose and one purpose
Okay.
only, and that's for the motion to vacate the scram device. So do you have anything else to submit, Attorney Bradel?
No, Your Honor.
Okay, Commonwealth, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is, in light of the court releasing the defendant, that testing be done.
Okay. Attorney Bradel, here, first of all, I do have a question. So Ms. Fitzsimmons is able to do the scrim, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
That depends on whether the court is willing to tolerate that the material represented in the
court
affidavit.
is not tolerating anything. Okay, let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to scram. If she cannot do that, I need to know that. Can she do that or not?
She can do it.
Okay.
Under the terms that are laid out in the affidavit.
So you're saying she can do it on her own terms?
With significant pain and dizziness and having to recover for several hours.
I understand what you're saying. It is certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all. So I appreciate your argument. Do you have anything else to add?
I would suggest that
cover your
I
ass
think there's
statement.
other ways to do this. If the court wishes to have her tested for lack of alcohol, that's completely fine with the defense. But just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that.
Torture.
Oh, okay.
But
it is not this court's intention
I understand.
to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that the defense views Ms. Fitzsimmons having to do the scrim as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that can be put in there as well. But Judge, I think that, that there's probably other alternatives that she could do that I believe are out there. But I know that might step on the court's other order for house arrest, that you would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go drink alcohol. That's not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue. Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes.
Your Honor, we're back on the.
Okay, so she does. She leaves for a few minutes to do whatever magic she's doing, talk to whomever she needs to talk to, and then comes back with this brilliant.
Record with the Fitzsimmons matter.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws Chapter 276, Section 58A2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to scrim monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the scrim installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by scrim, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by scrim. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A.
Unbelievable.
And you could hear at
Are
the
Unbelievable.
you calling him off?
at the end, you could hear her crying. And this, by the way, for those who might not remember, this is Kelsey here, and then next to her is Courtney, the paralegal. Courtney has no last name. I always call her Courtney, the paralegal. So, yeah, that's how that played out.
Unbelievable. And before we go on to it, because let's take a moment to all breathe. Let's thank Kay Schmidt for 5 Justice Serve TV memberships, and Lex Auditor for 5 Justice Serve TV memberships, and Wallflower, nice to see back, for 1 Justice Serve TV membership. We do have some questions that we can talk about. I'm trying to bring down the temperature for 1 second before I go a little bit nutso and go on a rant. Boston, Massachusetts 781. Aren't there alternative testing options for people with disabilities? Isn't this considered a medical impairment? That's a good question. And Joe Smo, Scram isn't just a breath test. It also offers ankle monitors for alcohol use. The Scram contractors have discretion to accept or ignore anomalies in the reporting from the monitors. And Joey Kane gifted another Justice Serve TV membership. And I just want to say to Joy Schmehar, apparently your uncle died. And of course, we are the community, and we are so sorry. So now that I've talked about, I've taken a breath.
Okay, let's talk disabilities, which kind of brings us back to the opposition brief, right? There's a big chunk in the emergency petition about the ADA, Americans with Disabilities Act, and how it plays into this scenario. Now, people might be thinking, well, wait, isn't that for stores and for businesses to make sure there are ramps or elevators? Well, yes, but it also applies to public entities and the judicial process. So the argument was made by Tim Bradle that not to accommodate her disability, being broken ribs, recovery from being shot, they're violating the ADA.
Bullet fragments
still in her back. All those things that prevent her from easily, or I should say less painfully, operating the Scram should be taken into account. What does the opposition brief say about the ADA? You just read it.
You didn't submit any evidence. That
Nothing. Nothing.
Yeah, well, I'm just going by the fact that they did have a footnote that said there was no medical evidence submitted.
Yeah, so in terms of referencing the ADA, nothing.
Right.
Now, easily, what they should have done, because they've given the court the perfect solution. Because if they had just put a sentence, paragraph, we don't believe the ADA applies in this circumstance, and quote cite a case. At least that's an argument, right? Now they've fallen down. They've done nothing. And so if I'm at the SJC, I look at the whole scenario. If I don't like how I can get there with the guts of the petition, I fall back to the ADA and say that by law, it falls within the judicial process, falls within the protections of the ADA. There's been no opposition to that by the Commonwealth. Therefore, I'm going to use that to come to the conclusion we need.
It's unbelievable. But did you hear her? Did you hear this judge? I mean, all of you that think that there's justice. And as I said to people, I'm not sure that if I were picking a career now after I've seen some of these things, because this is outrageous. I mean, remember what she's done here. She's given her house arrest in lieu of incarceration because she wants to protect the community and Officer Noonan, who's the one who shot her. All right. As if he needed protecting of her in that moment where she was going to, there's two stories, take her life versus she was going to shoot him, whatever. But to suggest that you needed to, you couldn't have a blood test, that you just could have a plain old ankle monitor that detected alcohol. And then maybe you can't with her because she has a medical condition and probably she has different medicines and ointments and all that are alcohol based and have alcohol in them, and it wouldn't be the same as a breath test at all that we're going to find that she has. But even with the breath test, if you have, for instance, if you put alcohol in your body, rubbing alcohol, cleaning, that gets absorbed into your skin. That could be exhaled out through your breath. I mean, this is just ridiculous. This is all because they have a contract with this company. That's what this is about.
Yeah, you would think since they do, and besides that, it's the defendant paying for it. They don't get into the defendant's paying unless they create some sort of waiver and waive those costs. So the ankle monitor should be at least an option, and then they can decide whether it's appropriate for a given. But apparently, it's not even an option in this case. It was the breathalyzer. Period.
Right. The breathalyzer period. But did you hear her? She's discounting January, who does these things all the time. That's what makes me think that she's never had one of these cases. She's never seen how they've done it.
it's not up for you to decide non-compliance. That's what
Me.
we do here. So
I'm the
harumph.
judge. Harumph.
Yeah.
I'm the one that got the judge. In
I
front
don't
of
see
me.
a robe on you, Mr. January. I felt sorry for him too, because he was obviously in the midst of some sickness, because he kept kind of choking on his words and clearing his throat and burbling. But he did a hell of a job trying to do the right thing, and this judge was
Educator.
just not going to have it.
Yeah,
Not going to have it.
And then she turns around Bradle's the torture.
The torture.
And
Yep.
all he's trying to do is let's have a less invasive way to protect. That's all. There has to be a less invasive way to protect somebody who has bullet fragments in them, who can't breathe. It's very difficult at all. And you've got her under house arrest. I mean, quite frankly, if she's under house arrest and has an ankle monitor, you know when she leaves the house. If she's drinking herself in the house, who the hell should care?
That's a good question. A different issue, but I'm sure the judge would have some interesting weighing in on that.
Sure. Somebody asked me if I could go to Massachusetts. Probably not after this case. Not after we discuss these cases.
I don't know that.
I will be invited back to Harvard again this year.
Yeah, I know. I already warned you of that. I don't know if I'd want to go there or not. I mean, I'm sure statewide that we're finding all of the aberrations. There are some good judges there, and hopefully they're the norm.
Where are they? Where are they? Where are they coming?
I don't
forward?
know. We haven't seen them.
Forward?
Maybe we're not seeing them because they're doing the right thing and things haven't blown up in the faces of them or their defendants or prosecution or anybody else. It just starts to look bad when case after case in that very small region, you go from Salem on the southeast to the just north of town in North Andover. It's a pretty small area, about an hour or so. You can get to all those places. Anyway,
Steve Weishaupt, 8591. I'm curious who she has let out on bond the past.
Yeah,
I don't know. Someone said she does civil. Would that be interesting? Is that this is her case? By the way, part of the remedy that Bradle's asked for is that when it gets assigned back, if it does get reversed, that it doesn't get assigned back to this judge.
Yeah,
but doesn't she have a superior?
Get rid of her. She's out.
Doesn't she have like a boss judge, a head judge?
Well, of course, there should be somebody. And even if it's not local, then there's going to be one county-wide. That somebody, she's not the boss. And somebody needs to, set her straight. I do appreciate how Tim, he has the Michael Bryant philosophy, which is, I'm not here to kiss the ass of the judges. I'm here to do my best for my client. So I don't care, judge. Say what you want. And the last thing you want to do if you're trying to get on the good side of a judge, which I never care about, is to say, I want you off the case. That will not endear you to anybody. And I think in a small jurisdiction like that, everybody knows what he's been doing, what he's trying to do, and how he's impugning that one judge. And they're either sticking up for her or they're going to try to distance themselves. At this point, it's hard to tell what's happening.
It really is. It's unbelievable. And we know that she's in jail and that she has been threatened by another inmate there, right? That's also.
Yes, that was in their petition. That, remember, cop, former correctional officer in jail, never good. And so this one inmate who happens to be a man who is transitioning to or somehow identifies as a woman, they put her in that facility, which I've always thought was disaster waiting to happen. And I just hope and pray that we aren't talking about this case in the very near future in terms of how she was injured or worse because they didn't fix this.
Right. Michael, I tell you what, it gives us agita and we're just commenting on it. It's not our case. I can't imagine what Tim Bradle is going through, having this on his back and also having the issue of the whole First Amendment on his back with Aidan Carney, whatever you think of Aidan Carney and all, but the whole First Amendment issue on his back. I just can't imagine it. And it's because we're in this small area that it's a small community. And we haven't even talked about the fact that the next community over is the Sandra Birchmore community.
Right.
We've had Karen Reed, we have Aidan Carney, we have Kelsey Fitzsimmons, we have Sandra Birchmore in this tiny
Brian Walsh.
Brian Walsh, right? Brian Walsh. It's lunacy. I'm sorry, but it's lunacy, Massachusetts. And I know that the Supreme Judicial Court's a good Supreme Judicial Court. They have some of the best decisions on forensics in the whole United States. They're great. They're far-reaching. They're far ahead of their time, right? Of all other jurisdictions and some decisions. So I hope they take your advice and they do the right thing here.
Yep. And there are 7 justices. So who knows if you're doing the single justice petition as they've done, I don't know, I guess you can get better than worse. Let's just hope that they get the right person who does the right thing. And as I've said, this judge, Judge McCarthy, she's done something that even Bev Cannoni never did. And that was to strip somebody of their freedom so quickly, so ex parte effectively. And you know, Judge Cannoni never did that. She may have tried on the big scheme of things to make it happen long term, but she didn't do it like that, as this judge did for Kelsey Fitzsimmons. And it's a horrible situation. So we'll keep on it. Maybe we'll hear something as soon as tomorrow. We can hope.
Okay, so we will see you all tomorrow night, 6 p.m. All right. There's a number of shows under discussion. We'll let you know tomorrow morning what they are. But in the meantime, you know, I'm Linda Kenney Baden. I've only been with you for an hour and a half. Michael Bryant has been with you for 5 hours today. So give him a little bit of a let's give him a little bit of a little bit.
It was interesting. Thanks everybody for joining. It's been quite the day. So join us again tomorrow. We are Just to Serve TV. So please try to do the right thing.
On the sky.